Hello, my name is Lonnie Rich. I'm a partner with Family First Law Group, and estate planning is a significant part of my practice. Today I'm going to address the question of what is a will. Well, it's a legal document that basically does two things. It provides for disposition of your assets at death, and it names the people who are going to get that done, as well as maybe do some other tasks that need to be done. So on the question of disposition of your estate, it's not just who gets your property, but it's also what they get or how much they get. There's also answered the question of how they get the property. Do they get the property outright and become the sole full owner with the right to do with it what they want, or do they get the property subject to a trust or subject to some other condition? And those are those are matters that can be dealt with in the will. With regard to the important players that are named in a will, the first that's always in a will is an executor. The executor executes or carries out the terms of the will. I think of the executor as sort of a short-term liquidator. It's a job that takes anywhere from 6 months to 2 years, depending upon a number of factors, including the complexity of your estate. Another important player is a trustee. A trustee is a long-term asset manager, usually for minor children, sometimes for others who are adults who are immature or have disabilities or any number of reasons why they may need help in managing their assets on their behalf. And then the final fiduciary that's often named in a will is a guardian. The guardian that's the person that's going to take care of your minor children. There are any number of types of wills. Lawyers pretty much do formal wills, and I'm going to talk about those in a minute. But there are two other kinds of wills that exist. One of which is not uncommon, but is a holographic will, and that's a will that is written entirely in the testator's handwriting. So the person who's thinks they're about to die, they can write out their own will and just write it out, but it has to be entirely in their handwriting, and it does not need to be witnessed at the time that it is signed, but it does need to. But the signature on that handwritten document does need to be proven in order to probate that will. But there's another kind of will, and it's called an enunciative will. It's an oral will. Now, I've never seen one. You don't see it, but I've never heard of one happening in my practice. But it is possible, but it is only for an extremely limited situation. It is for soldiers, military personnel who are on their deathbed from service-related injuries. And that is the only time that you can have an oral will that would be enforceable. And so most wills are formal wills. They are typed out and they are prepared by attorneys. And the next thing I'm going to talk about is what's in a will. What do you have to put in a will? Well, the things that are in most wills are the following. There's usually the very first line takes care of an important element of the will. That's testamentary intent. And that's really to distinguish the will from some other document. So it's not a deed, it's not a power of attorney. Well, so how do you just say, and the language is usually, this is my last will and testament. That expresses testamentary intent. The next section is usually informational. It describes and provides names of family members and friends who are either going to be beneficiaries or who are going to have jobs to do. They are named as executors, trustees, guardians. The next section is usually specific gifts. And the specific gifts are those can be, it could be a piece of property that you give to somebody. I give my home to my spouse. If she fails to survive me, I give it to my son John. That's a specific gift of real estate. Another kind of specific gift is I give $500 to my cousin Joey if he survives me. If he fails to survive me, this gift shall lapse. That's another kind of specific gift. Usually another section, it's usually all lumped together, is called tangible personal property. That's all the stuff that's in your house, that's your cars, and any other tangible personal property. It's hard things. It's physical things. It's not bank accounts. It's not money. It's not real estate. So it's tangible things, and those are usually there's usually a special section for tangible personal property. The next section is the residuary clause, and usually that's where most people give all of their property. And the residuary clause is a provision that says, I give all the rest, remainder, and residue to my spouse if she survives me. If she fails to survive me, I give such rest, remainder, and residue to my children in equal shares. That is a very common kind of residuary provision. Most people also have what I call a default provision in their residuary clause, which is they have the main people that they want to benefit from their estate. But we don't know we don't know when this will is going to be needed or who will be alive at that time. And so there's sometimes a provision that says if all the people I've named above have predeceased me, then I give all the rest, remainder, and my residue of my estate to my church or to my charity or to my friend Joe or some other disposition. The next provision that's in a will is usually a section that names those people who are going to take care of business. It's the executor, the trustee, and the guardian. And it's usually common to name alternates because, again, whoever you name may not be available. They may be disabled, deceased. A lot of things can happen, or they just don't want to do it anymore. So it's good to name alternates. Then the final substantive provision is the boilerplate, and it's where all the language is that is helpful. It provides definitions. It provides powers. Usually powers of your executors and trustees are named or identified there. There are any number of provisions that don't happen very often, but if they do, it's helpful to have these things in your will. Then after that is the signatures. And the person who's writing the will has to sign their will, and there need to be 2 witnesses for a formal will in Virginia. And then after that is another page, a separate page that we do with every will. It's called a self-proving clause, and that is basically an affidavit in which the parties, basically the person who's writing the will and the witnesses all basically acknowledge that that the person signing the will has indicated that it is their will. They want the other people to witness their signature. They're all in the room together and they're observing the signatures, and the person's 18 years old and appears to be of sound mind. So that's, the reason that's important is because that means when the will is probated, those witnesses don't have to show up, because you have that affidavit which provides all the information that they would provide if they did show up. So that's what's in a will. One other thing that I just want to talk about wills is what is governed by the will. Well, sometimes it's easier to talk about what's not governed by the will. Property that you own jointly with somebody else with rights of survivorship is not going to be governed by the will. That's governed by operation of law. When one joint owner dies, the other automatically becomes the sole owner of the property. The will has no impact on that. The other property that is not governed by the will is property for which there is a beneficiary designation. The beneficiary designation always trumps the will. And the kinds of properties that, assets that have beneficiary designations are life insurance, retirement, IRAs, annuities, and some bank accounts or brokerage accounts can also have payable on death or transfer on death beneficiaries. And if they do, then it's those beneficiary designations that will control. And the reason I want to point this out is because oftentimes the will only governs a small part of your estate. And so it's important that you make sure that when you do your estate planning, that you think about what these other assets, what they do, and whether they are overall consistent with the plan that you want to achieve. A lot more could be said about wills, but I hope this has been helpful. If you have questions, please feel free to give us a call. We'd be happy to work with you and try to answer your questions. Thank you very much.